Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
So today is part 2. In part 1, we talked about trying to see if you could resolve your case before filing suit. And, we're going to exhaust in all of our cases, all avenues in those situations to try and get cases resolved without litigating. But as we discussed, there comes a time when you got to litigate, and that there's various reasons for it, but primarily nothing's going to happen in the majority of cases unless you file suit. Now, commencing legal action and filing a lawsuit and filing a summons and complaint, it doesn't mean you're necessarily going to war. It doesn't necessarily mean that you're in it for the long haul, or that once you file suit, it means, you've got years to go. As we all know, litigation happens in phases and takes on its own sort of life of its own. And sometimes just by filing the complaint can make a difference in getting cases resolved. So let's say you start off the case, everything we talked about last month in part 1, making calls, sending letters, trying to get things moving, maybe to mediation, maybe just getting an offer up, and nothing's happening, right? Or you're not getting return phone calls from the carrier or the defendant, and you're on the plaintiff side. So, sometimes just filing the complaint gets you a whole new team of people involved. Oftentimes it'll get assigned to a new claims representative or adjuster once it's in litigation. You get the lawyers and law firms involved. So it's not uncommon that once we file suit and we see the firm answering it and we get on the phone with defense counsel, that we're able to move the dial even further than before filing suit. Sometimes you got to go the distance, and we're going to talk about that, going that distance up to and trying to get your cases resolved before trial, hence the win before you walk in to trial. So what we're going to talk about today is framing the complaint, and it's more than just the actual nuts and bolts of how to actually draft a complaint, but we're going to talk about jurisdiction and venue. These are things you may have skipped out on that day of civil practice in law school. So we're going to do a little refresher on jurisdiction and venue. We're going to talk about filing in state court versus federal court. We're going to talk about making sure to identify all the proper parties that you need to name in the complaint. We're going to talk about different styles of complaints and making sure that it's properly served. In the materials, for those of you who have worked with me in these CLEs before, I don't like to take time away from chatting with you to look at materials, but they're there for you. And in there, you'll see I've got the statutes on jurisdiction and venue. So if you need a refresher after we chat about it, it's there. I also included a bunch of complaints, some state, some federal. You've got a tree fall case, an auto accident in state and in federal. You've got a product liability in federal court. You've got a construction accident case in state court. I think we have a premise case in there. So you've got a nice mix in the materials. You can look through now. I'd prefer if you wait until afterwards so that you can use as samples for yourself and as guides to walk you through. So I always find as a lawyer attending CLEs, I want materials that are practical and giving you a bunch of different complaints you can copy or modify or look and make sure if you're missing something. I think that's a value. So that's why I gave that all to you. Also in the materials, I've got a civil cover page example for federal court. I have a sample certificate of merit for medical malpractice. We do have a medical malpractice complaint in the materials. So take a look through. There's some good stuff there. Feel free to use it as you see fit. Again, just sort of some housekeeping stuff. I love questions. That's what I'm here for, to answer the questions you have. So if you don't ask them, I can't answer them. Hopefully, I will cover most of the stuff that's on your collective minds during this program. But please ask away during the breaks, the polls, whatever. I'll take a quick look and I'll try and address questions if I have time throughout this first hour. If not, stay on from 2 to 2:30. We'll go through all the Q&A. I'll make sure to hit on everything that I can in that half hour, and you'll also get additional credit if you stay on for that extra half hour. Lastly, I just want to remind everybody what a great organization the Academy is. There's currently over 800 people right now on the CLE. And if you're not a member of the academy, what are you waiting for? Now's the time to do it. Michelle's got all kinds of committees for you to get involved in and really make a difference. And I personally have escorted a lot of people from my mentorship program into the academy, and they're already on the boards and associate boards, and they're going on the trips to Morocco and lobbying and doing all kinds of good stuff. So I encourage you, if you have any questions about membership, feel free to reach out to me or Michelle, and we'll help you out with that. All right, so let's get to it. We're transitioning from part one, and now we've made the decision. All right, this case isn't getting settled right now. We've exhausted all of our pre-litigation strategies and techniques. So now it's time to get that complaint started, get this case into litigation, and see where it goes. Okay. Now, the first thing that you really need to think about are the who, what, and where. All right, for purposes of litigating a case. And first, we're going to talk about the where. That's jurisdiction and venue. And let's talk a little bit about both of those. So jurisdiction, at least for New York, and I know there are several of you who are not in New York who may be listening to this at some point. So check your local statutes and rules in your state. We all have to follow rules as lawyers, and looking at the rules is, the very important thing to do. So look at your civil practice rules on jurisdiction and on venue. In New York, you've got CPLR, Section 302, and that's New York's long arm statute, and that's in the materials. And basically, the idea with jurisdiction in general, anywhere, any state in the country, is the courts in the state that that you want to bring the case in, they have to have some legal right to drag somebody into that court. All right, so if someone's mad at me, they hear something on my lecture and they want to sue me in Texas, they have to figure out, how does Texas get jurisdiction over me? Was I in Texas when I did something? Did I have an accident in Texas? Do I have a home in Texas? Do I have a principal place of business? There has to be some connection. That's what's called jurisdiction. If you don't have the ability to get jurisdiction over who you want to bring the lawsuit against, then your case is a nullity and it can't be stipulated to. I'm going to talk about in a moment a federal court case I had where Judge Hellerstein, who many of you have heard of, very well-known federal judge who's often quoted in the news here in New York. I had a case that Judge Hellerstein was questioning jurisdiction and wanted to make sure we had it, which ultimately we did, and we were right. But because you can go the whole way, and even if the judge thinks you have it and your adversary doesn't dispute it, you can get a verdict. And if after a verdict there's an appeal and it's determined that you did not have proper jurisdiction over the defendants, somehow you come up with that later, then it's gone. The case is a nullity. You cannot stipulate to jurisdiction. All right, the state has to have it. So first, you want to see how you can get jurisdiction. Now, I'm going to talk about a typical auto accident case right now in New York to help with this problem. In a scenario where, let's say, your client, whether you're a defense lawyer or plaintiff's lawyer, your client is involved in an automobile accident in New York with another vehicle. In that situation, if the accident happened in New York, you have jurisdiction. If because the person, even if they were out of state in the other car, by being in New York State where the occurrence happened, you've got jurisdiction. Okay, they came into the state, had an accident. It's by being in the state you have jurisdiction. Now, what happens if everyone's from New York, the accident happens in New York State has jurisdiction, no problem. What if the plaintiff is in a car and has an accident in Manhattan, and it's someone from Connecticut with a Connecticut driver's license, Connecticut registration, everything. They just happen to be coming in for business that day. You still have jurisdiction over them because they were in the state. All right, so you have jurisdiction. Now, what happens is if in that automobile accident, it happened just north of New York in Connecticut, in Stamford, and the plaintiff is a New York resident, lives in New York City, lives in Brooklyn, Manhattan, pick your borough. Their car's registered here. They're driving out of the city to go somewhere, and they get in a car accident in Connecticut with a Connecticut resident. You don't have jurisdiction in New York, okay? Because the defendant lives in Connecticut, the car is registered in Connecticut, and the location of the accident is Connecticut. So, unless there's some other way that you could find and connect the defendant, maybe the defendant has a home also in New York. Maybe the defendant was in a business, a corporate vehicle, commercial plates, and that business is located in New York. You have to do your homework, all right? So read the statute, but the idea is if it's an out-of-state tortfeasor, you've got to get them in the state. Otherwise, you cannot bring the case here, all right? And these are sometimes difficult decisions. By way of an example, we had a case, we were consulted by somebody who slipped and fell and fractured his skull and had a very bad go of it while on vacation at the Hyatt Acapulco, Mexico. And they were from New York, the clients. So they called me. They said, what do you think about handling this case for us? So I did my research and I found out that the Hyatt in Acapulco, there's all what you'll usually find is these types of international like Hyatts and Hilton hotels, big chains around the world. They'll all have these sort of sub entities in the local place. So this Hyatt Acapulco had a local Mexican Hyatt entity that we couldn't get jurisdiction over. But we were trying to figure out how can we get the Hyatt here into New York. So I did a bunch of research on business contacts and do they have a website? Can you book in New York through a website? Do they market to New York? There's all these interesting things when you do your research about getting businesses from outside of the country and outside of the state, having contacts. It doesn't have to be a principal place of business. It helps if they have one. So if Hyatt has their headquarters in New York, that's a plus. Sometimes you got to fight out with the sub entities. But at the end of the day, we said, let's give it a shot. So we brought it in federal court under federal diversity, and which we'll talk about. And we said, well, let's see what happens. They're going to make a motion probably to get out of the case on jurisdiction, which they did. And we pushed back. And ultimately, we actually got the case settled because while the motions were pending, the lawyers for Hyatt and Hyatt themselves weren't really too thrilled about getting a federal court decision saying that, yeah, you have jurisdiction in New York for an accident in Mexico based on contacts, because I think they were concerned that it would open up the door more. So that was just strategically figuring it out, taking a leap, getting involved, knowing there's a chance we could have lost, but we won it and we got the case settled. So we did get tentatively jurisdiction, although the motion was pending. So these are things you have to think about jurisdiction. If it is a corporate defendant as opposed to an individual, you can get a little more creative. Like I just talked about with Hyatt. Are they selling their goods here? Do they have a principal place of business here? Do they transact a lot of business here? So you need to confirm jurisdiction before you file suit. Okay. Now, the other thing that you want to think about in jurisdiction is in a wrongful death case. What forms the basis of jurisdiction? Is it the state where the accident happened? Is it the state where the person dies? Is it where their executor lives? So we had a case, and this was the one with Judge Hellerstein, where, and I'll talk about this case, I've talked about it in other CLEs because it gives a lot of good learning lessons. Our client was involved in a very bad fire in Co-op City in the Bronx. And he was burned and had a brain injury, so much so that his sister, who was a lawyer, got appointed as his guardian for all purposes, taking care of everything. And she's the one who retained my law firm, the sister. Now, the sister lived in Washington, D.C. The guardianship proceeding happened up in New York. He was alive. And so the way that the law works is that if it's a death case or a guardianship case, the location of the administrator, guardian, executor, where their residence is at the time of filing suit, is used for jurisdictional purposes. Okay. So she was in DC, and even though guardianship happened in New York, because my client was technically from out of state, District of Columbia, and because the defendant was building that owner in Co-op City in New York, I had diversity of citizenship for federal court. So I could have brought the case in the Bronx because that's where the defendants were located. That's where the site of the accident was. I could have brought it in Bronx Supreme Court, or I could have gone the route and gone to federal court in the Southern District of New York based on diversity. And that's what we chose. I'm going to talk about that a little bit, what went into that thought process. But the interesting thing is once we filed suit, Judge Hellerstein called us into chambers and sat down with us, not his clerk or anybody else. And he was like, I'm not so sure you've got jurisdiction here and to be in federal court. Where's your diversity? The injured plaintiff lives in New York. They're all in New York. And when I explained that the guardian is in a different state, the judge wanted to see some case law, some statutes, which I gave him, and he was satisfied, and the defense didn't push back, and they were satisfied, and we went underway. So when you're thinking of jurisdiction, if it's a death case or a guardian case, you definitely want to consider where the guardian, administrator, or the executor lives if they're the plaintiff. Okay, that's going to go into jurisdiction. Now, once you get jurisdiction, then you need to decide venue. So think of jurisdiction as state, think of venue as county. All right. So let's say it's an automobile accident that happens in New York, and it's a New York plaintiff lives in Brooklyn. The accident happened in Manhattan, and the defendant is in Connecticut driver from out of state. Well, we know you have jurisdiction now under the long arm statute, CPLR 302, over the Connecticut defendant. And since the plaintiff lives in New York State, you have jurisdiction in New York State, and you have it over the defendant. So now the question is, where do you file? Well, federal court is out because they're, actually, no, federal court is in, right? You have a choice because you have parties from different states. You have a New York State resident, and you've got a Connecticut defendant. So you can bring this case under the rules of diversity in federal court, or you could bring it in New York State. So for the moment, let's decide we're not going to bring it in federal court. We're going to bring it in New York State. So then the question is, where do we file it? Which venue? Well, here you've got two choices. You have the residence of the plaintiff in Brooklyn, that's Kings County, and you have the location of the accident in New York County, Manhattan. So you could choose between New York County and you can choose between Kings County. And you can file in either of those. And that's good venue and good jurisdiction. And then you need to make a decision. Is New York better for this case, or is Brooklyn better? What if you had a Westchester plaintiff? Then you can choose Westchester. But a plaintiff would rather be in Brooklyn or New York than they would in Westchester. So obviously you'd make that decision. Okay. So you're going to look at that. So under the CPLR for venue, that's Rule 503. That's in the materials. And basically, you're thinking of three things. Where does the plaintiff live? Where does the defendant live? And where did the accident happen, or the bulk of the circumstances that make the basis of the lawsuit? That's the technical way. So you got residents, where they live, plaintiff, defendant. You can bring them in any of those counties, and you could also bring it into the county of where the accident or the incident happened. So if the incident happened in Queens, person lives in Brooklyn, and out-of-state defendant, you can pick Brooklyn or Queens. If everybody's in New York and they're all New York automobile drivers, registration, live in New York City or the counties, and let's say you've got a plaintiff from Brooklyn and a defendant from Westchester, you can sue in Brooklyn, even if the accident happened in Westchester. Okay. Now, if you're on the defense side, you can always try and remove a case to a different county, but if it's just venue, it's really hard. You really would have to show that all the witnesses are in one place. So this usually happens in, let's say you have jurisdiction in New York State. So for example, I've got a ski accident case up at Hunter Mountain, which is further north than New York City. But let's say my client lives in Brooklyn. Do I want to bring the case in Brooklyn, or do I want to bring it upstate? Do I want to bring it in federal? So these are all things we'll talk about deciding state versus federal. But just in venue, you have some choices, and you want to pick the venue that you think is going to be best for you. So the start, the CPLR 302, 503 in New York State, that's jurisdiction, that's venue. Know where you can bring the case. Then you start workshopping the pros and cons of where to file it. So I want to pick up on venue decision and give you an example of my process that I recommend to sort of how you sort of work these out. So I had a medical malpractice case where someone died during a procedure at New York Presbyterian Hospital. And we had a choice of bringing it where the estate was in Queens or bringing it in New York County where New York Presbyterian was. So those were the two choices for venue. And I had to think about and workshop, where should we file this? Should we do it in Queens or should we do it in New York County? Where would you file it? If you're a plaintiff's lawyer and you've got a very serious, heavy damages medical malpractice case, and you have a choice between Queens and New York, where would you file it? So some of you are probably thinking New York, some of you are probably thinking Queens. Okay, that's the decision. So what did I do? First, I spoke with the other lawyers in my firm at the pros and cons, the juries, the judges, the location. And then I spoke to two other past presidents of the academy who were both excellent medical malpractice litigators. And I asked them, one of them said they would go with Queens because the jury pool is going to be much better for a medical malpractice case. The other one said they would go with New York County because the jurors are probably close, maybe not as great, but in New York, it's going to move faster, more judges with specific medical malpractice parts. And also, it's a little bit more user friendly if you're located and your practice is in New York. So those were the two choices. And ultimately, I decided to file in New York County because it's more of my home court. I'm in New York County much more than I am in Queens. I know that the judges are really good in the med mal parts. They specialize in it. And I figured that I would feel more comfortable and at home and have more success there. So that's how I chose it. Ultimately, the case worked out. It got resolved prior to trial. Now, I don't know if it's because it was in New York necessarily, but we had motion practice. We had a really good judge who gave indications of things and had a tight leash on the case. So I think it did help that I was in New York County for that one. So that's a decision that sort of goes into play. Think of your local courthouse, the one that you go to most, whatever county you go to most, that's your home court. And it's like sports. Would you rather play a visiting team on your field or would you rather go to the visiting team's field, right? There's lots of things to consider. So workshop it with whoever. You can always reach out to me. As I hope you all know by now, you could always book a Zoom with me. You could do it right on this link here or just go to the Mentor ESQ. I do complimentary Zooms, and I'm always happy to chat about anything, and I would be happy to workshop venue and location. All right, so those are the things you want to consider. All right, now let's talk about federal court. So I mentioned earlier in the same case, the fire case that happened where I had a choice of bringing it in the Bronx Supreme Court or in federal court based on diversity. And ultimately, I knew that the Bronx jury would be much better than having to have a jury in Manhattan in the Southern District. In federal court, it has to be unanimous jury. The judge needs to put a minimum of 6 people in the jury box. Usually they'll put a minimum of 8 without designated alternates, and that 8 has to be unanimous. If you lose down to 7 or down to 6, whatever you're left with, as long as there's 6, it has to be unanimous. Now, unanimity is not always a great thing with jury verdicts, getting everybody on board, especially if you're the plaintiff and have the burden of proof. It makes things a little bit more tricky. But the other things to think about is, first of all, you have to have diversity of citizenship. This is in the materials. It's a statute, 28 USCA 1332. And basically, if you think of the V in a caption and the plaintiff at the top and the defendants at the bottom, and I remember this from law school 30 years ago, that on each side of the V has to be separate states. You cannot have the same state on the plaintiff side and on the defense side. You lose jurisdiction. You need separate states in the V. You can't have same states on the plaintiff side and defense. So you need diversity, all right?
Attendance code number 1 is WIN 102. That's WIN 102.
Then the matter in controversy has to be more than $75,000. And that's just an allegation. You don't need to give proof of that. And if your case ends up going downhill or you find out there's only $25,000 or $50,000 of insurance and you need a compromise order in federal court, the judge is not going to yell at you that it's only $50,000 or $25,000 and you brought the case. As long as in good faith, you believe the potential damages are more than $75,000, then you can do that. Again, in a death case, you're going to look for the residence of the administrator or the executor to determine whether there's diversity there, okay, what state they're in. Now, I've talked before about litigating cases in federal versus state court. I've done a whole CLE on that. But there's just a couple things to think about if you're debating which to bring it into. There's pros and cons, all right? The biggest pro to federal court is the rules are the same in any federal court anywhere in the nation or in the U.S. Virgin Islands or Puerto Rico, where they have federal courthouses. You can walk into a federal courthouse or litigate a case in any federal court in the United States, and the rules are the same. Local rules may be a little different, but it's all the same. Same for trial, same for litigation. So there's a nice sense of knowing that what the rule book is, because even in New York State, as many of us know, litigating in one county versus another, even in New York City, in different boroughs, depending on the judge, depending on the process, it's like being in different countries, right? So federal court, you know what you're getting into. You know it's generally going to go faster, generally, not always, but generally faster than state court. You have access when there's discovery disputes right to the judge. You can have a conference within a week or so. You're not stuck with filing motions for discovery that could take months or years to get decided and to really drag out the case. You can get trials usually faster. You can keep out nonsense with the Daubert motions. Being able to question the other side's experts before trial, I think is fantastic. You can move to preclude their testimony. We do that a lot. So there's no surprises showing up at trial because they serve you with a 3101D disclosure in state court the month before or even the day before. So for those reasons, I like federal court a lot. I like that the judges are smart. They know what's going on. You can usually, if you're on your game and know what to do and you're not a slacker and a rule follower, federal court could be a really great experience. So I like that. Now, on the downside, the cons, the two primary cons are, one is the cost. It's a big cost. Because there's depositions of experts, there is expert discovery. You do need to exchange expert reports. You're spending a lot of money to litigate this, whether you're plaintiff or a defendant. Federal cases get expensive. Think about it. If you want to retain a biomechanical engineer or even just an orthopedic surgeon, they have to write a report. They have to do an evaluation. They have to review everything. They're going to charge you several $1,000s just for that. Then you're going to have to pay to get them to prep and to show up for a deposition. Now, generally how it works is the other side who wants to question your expert has to pay for it. But the pricing has to be appropriate or it goes to the judge. And you have to pay money to take the adverse experts' depositions. So it gets really costly. Those numbers build up a lot. It can take a while. It can be a lot of heavy motion practice and eliminate motions, Daubert motions. And the motions, sometimes I've been seeing delays in federal court on, I have a summary judgment motion I filed in the Southern District last June. I think op was in July and I'm still waiting on a decision. I reached out. I was told by March I should have it. So in general, there are pros, but there are also some cons. If you're not on your game, if it's not really a case you want to invest money into, if you're worried about a unanimous jury, you're worried that you may have to send per diems to court and federal judges don't like that, then stay away from federal court. But what I did in my fire case is ultimately we decided that if we were in the Bronx, even though it would be a great jury for our client, and possibly get a huge jury verdict if we went that far. The downside was I knew I was going to be requesting a lot of discovery on smoke detectors, there's lots of discovery I was going to need from the ownership of the complex and the buildings. And I had a very strong suspicion that was confirmed that they were going to give us a really hard time. We were going to need to do testing of the smoke detector at a lab. We were going to need to do all kinds of stuff. And I figured that even though the jury pool wouldn't be as good in New York County as in the Bronx, that the case would move faster and potentially towards resolution faster. And I wanted a federal judge to be strong with the orders so we can get the discovery and we can move the case, especially with multiple parties that were brought in. I didn't want this thing to just become a monster in the Bronx that disappeared down a rabbit hole. And it ended up being the right call because numerous times they didn't give the discovery we wanted. After getting the federal judge involved, we got the discovery. Numerous times we tried to set things up that they were trying to adjourn. It was hard to get everybody, all the parties together to do an evaluation of the smoke detector at a lab. They weren't happy. They didn't want to go. One of the defendants says, I'm not agreeing to proceed. We got the judge on the line and the judge is like, no, this is going. This is moving forward next week as planned. So ultimately that really helped. And then by getting all the discovery, getting all the depositions, having the judge on speed dial, basically, the case kept moving to the point that we were able to get a lot of information early and get it into a mediation that ultimately resolved the case, I'm sure years earlier than if we brought it in the Bronx. All right. So it's up to you to make those decisions on venue, jurisdiction, state court, federal court. Again, I'm always happy to workshop that with you. Lots of pros and cons. But ultimately, what we're getting at here is you have choices. And what we do as litigators is a little science, a little art, a little creativity. And you have to think these things through. Don't just automatically file in one type of location, one case. There may be benefits to seeing other options from state or federal or county and venue. So put some time into that. It's really important before you file suit, because once you're underway, it's super hard to leave the venue you're in. Okay. I'm not going to get into that at the moment on how that happens, but the defense can remove it to federal court sometimes. They'll do that if they can. But for the most part, once you're in a place, you're going to stay there unless there's a real reason not to. So choose wisely. Okay. Now we're going to start working on the complaint, and we're looking at the litigation, and you need to figure out who to identify. Who are the proper parties? Who are the plaintiffs going to be? Who are the defendants going to be? Now, from the plaintiff's perspective, it's pretty easy. It's anybody who is injured in the accident. Oftentimes, it's one plaintiff primarily. Now, if that plaintiff has a spouse, then you need to have a discussion with that plaintiff of whether or not that spouse wants to be a party to the litigation. Talk about loss of consortium. That generally will only be a line item if it goes all the way to verdict at trial. Otherwise, a settlement, the husband and wife will get the money together. Payment will be made to both of them, even if one of them was the injured party and the other just has a consortium claim. And then, they're married and they're together. Sometimes it's just not worth it to add the spouse as a plaintiff. They're going to have to be deposed as well. So you want to have a conversation with your clients to see the extent of the loss of consortium, to see the extent of the knowledge of the spouse, whether they're now a caretaker of the plaintiff, whether they're a good damages witness who can talk about what the plaintiff went through. Then it's okay to have them as a party. If they're really not involved and not interested, it's okay not to bring in on the consortium. It's okay. You just need to have that discussion with the plaintiff and potential spouse, and that's who your plaintiff is. If it's a minor or a guardian case, you would obviously name the parent or the guardian or the executor as the administrator on behalf of the estate or the minor. Okay. And if it's a minor under the age of 18, you have to use their initials. You don't put their full name in when you're filing a complaint. So instead of Andrew Smiley, who's 17 or 10 years old, it would be A.S. an infant. Okay. My parent and natural guardian for A.S. an infant. All right. Now, the defendants are going to be a little trickier in how to decide who the proper defendants are. But again, this is super important, folks, because a lot of times we're drafting these complaints with the statute of limitations running, or it's going to be running in 3 to 6 months or a year even. You don't want to start a case only to find out a year later that you're missing a party and the statute's run. So the first thing you need to do, if it's more than just a complex case, a basic case, if it's more complex, you're going to want to hire perhaps an investigator and do some research. So let me talk about the scenarios. An auto accident, that's going to be generally the easy part. You're going to make sure you name everybody on the police report as a potential defendant whose car was involved in the accident. Usually it's simple. It's just the defendant. You're going to sue the driver and the owner of the vehicle. They're both liable under the law. If the driver is driving with the consent of the owner, then the owner under the vehicle and traffic law is vicariously liable for the actions of the driver. So you're going to name the driver and the owner. Sometimes it's the same person. Sometimes it's not. So that's an easy one, an auto accident. But what about a more complex case? What if it's a premise liability case at a construction site? Someone trips over something outside of a building and there's a lot of construction and wires and all that. You've got to bring in everybody. That's where you're going to want to go out and do your own investigation. You're going to want to maybe have an investigator look in. You're going to want to research who owns the property, who leases the property. Was there a commercial lessor? Is it private property, commercial property, public property? You're going to want to find out who the owners are, and then who caused the accident, who put out that cable that the plaintiff tripped over. Was it somebody working at the building? Was it the construction going on that day? If it is, you want to bring in the construction companies. Was it Verizon running some cables that day? So you need to identify every potential defendant and put them in. So this is why you want to start your investigation pretty early. Investigators will pull deeds for you, they'll identify the owners, they'll canvass for witnesses and video surveillance to see who is doing what, when. If it's a premise liability case, you're always going to want the managing agent, right? If it's a slip and fall in a building, you've got those cases, maybe it's raining out, no mats down, they walk into an office building, they slip and fall. Who do you sue? Well, you do a search, you find out who the owner of the property is, the building owner, you sue them. You're going to want to go look. Usually there's a display somewhere of who the managing agent is in the lobby. You're going to sue the managing agent because usually they're the ones overseeing maintenance. You're going to want to find out if there's an outside maintenance company they use. So these are conversations that are good to have with the insurance claims rep. When you get the letters of acknowledgement, when you send out a claim letter and you get it back from the insurance company, see who their insured is, ask them if they've done their investigation, were there any other entities there? So that's where you want to, we talked about last time, getting off on trying to establish a good rapport with your adversary to get to the bottom of it. All right. Is there a holding company? Is there a sub company? We have a case against, we have an accident case that took place at Javits Center. All right. We had to file notices of claims. We had to, because they're a quasi, municipal entity. We had to sue them. We had to sue the event planner where the event happened. Then we had to find out where they got the furniture from that was defective, that caused the accident. So sometimes you don't know everybody at the outset, but you want to explore and put every defendant in there that you can at the outset. And in the case that we had where it was a swing table, it is a swing table case. My client was at an event at Javits Center and it was being put on by a company. It was a big tech event. They sat on the swing table. They leaned back to take a picture. The whole table flipped over and she smacked her head and got a really bad brain injury. So we sued Javits. We sued the entity that was running the event. And then we spoke with them and they were still in their investigation. But then we saw that after we started our suit, they found out that they got the swing table from an entity out in Vegas. So they third-partied them in. Immediately, we added them as a direct defendant while the statute was there. So you really need to explore everyone as possible. And I'm sure I'm going to get a question from you, somebody, what if you can't find the right entity within the amount of time to file? Well, that's a problem. And if a client comes to you late or with the statute running, you should disclose that. Say, look, we're going to name everybody we can find, but you came to us at the last minute, and there's possibly other tortfeasors out there we may not get to within the statute. And you need to know that's not on us. It's on, we're limited with time. So it helps, obviously, if you get a case early, but don't sit on it for a while. Start doing this homework while you're in this investigation phase before filing suit. You don't want to wait until the last minute and say, oh no, we got to file summons and complaint. The statute's running next week. We couldn't get this case settled. And now you're scrambling for who to name. That's going to be on you. And that could be legal malpractice if you mess up there. So start this process early. Construction accident cases. You're going to want to name the owner. You're going to name the general contractor. Sometimes they call it a project manager. You're going to want to find out any of the subcontractors on site, any rental companies, if there's a piece of equipment, who the manufacturers are. So you're going to want to find out all these entities and bring them all in a construction accident case. If it's early on and the construction site is still there, you just go right over to it or send somebody and they have all the permits up, or you pull the permits. That's one way you find everything out. So do your homework on that. On a product liability case, you're going to want to name the manufacturer of the product, the designer of the product. Sometimes they're the same, sometimes they're different. You're going to name the distributor of the product. You're going to name the retail seller. So let's say it's a piece of exercise equipment like a resistance band. It's manufactured abroad, it's brought in, and it's labeled by some Acme corporation here in the US. Acme then distributes it and sells it to Dick's Sporting Goods. The client buys it from Dick's Sporting Goods. You're going to name everybody. Sometimes it's tricky when the manufacturing is done abroad or in China. Usually you don't need to bring them in. It's enough that you sue and name the local entity in the United States that basically designed it. Usually they'll design a product in country, ship it out because it's cheap to be made. Then it comes back with the labels on it, ready to go to be distributed. So usually, as long as you have the person who designed it, or rather the company, and distributed it in the retail store, you're good. And then lastly, you have the Jane and John Doe defendants. So let's say it's an assault case at a bar, and you know your client says, I know there was a guy named Mike, and he was the guy who was arrested. We have his first and last name, but there was another guy, and I don't know his name, but he was there. I know it for sure. And, so in that instance, what you would do is you would name John Doe, or if you think it was a female, Jane Doe, just as sort of a placeholder. You can do that, or John Doe Corporation or Jane Doe Corporation, upon information and belief, was a subcontractor. Their true name is unknown at the time of filing. And then you could sort of slot them in when you go to amend. It's not necessarily going to toll the statute of limitations for you, but at least it's giving a good heads up to everybody involved that you're doing your due diligence and you think there's others involved there. So thanks. I've just looked at a bunch of the questions. They're all great, and I'm going to get to all of them in about 10 minutes. So I'm just going to try and continue through, get you some more information that you tuned in for. All right, so let's talk about complaints. So you figured out who you want to name. I've given you examples of complaints so you can see how to name it. Now, complaints in general, in New York State, we're considered a general pleading state. You don't have to put in a ton of details. It's not specific. You don't have to put in on line 1, so-and-so was driving on this day, stopped for coffee, did this, did that. I mean, you don't need it to be super specific. When you look through the ones that I have in the materials, it'll give you an example. So don't worry about too many specific details in a New York State or federal complaint. However, you do need to be careful that you have all of the appropriate causes of action in. And I'm going to talk about that now for a quick moment. So whether it's state or federal, if it's an auto accident case, right, you're going to want to make sure, that's generally a negligence. But if you have VTL violations you want to throw in, I would do that. It doesn't hurt. Certainly in federal case, if you think there's some drinking that might have been involved, drunk driving, you're going to want to find out the restaurants or bars. You're going to want to name them. You're going to want to put in addition to the regular auto accident cause of actions for negligence, not using your horn, brakes, being on a lookout. You want to consider the dram shops, which is General Obligations Law 11-101 and 11-100. You want to maybe put in for negligent supervision. If it was a younger person driving, maybe negligent maintenance and repair of the vehicle. Maybe there's a product claim that you want to put in there. In all cases, if you think there's an element of punitive, put those in the complaints early on. It's much easier than adding them later. That's kind of a pain to add punitive when you find more stuff out. Construction accident cases, again, you got to make sure you have your labor law 240, 241, 200, common law, possibly a products case. So possibly spousal claim for both. Okay. So you want to make sure you have all the causes of action in there. It's always easier to take one out than to add one in. Medical malpractice cases, you're going to want to have medical negligence language, departure from standard of care, lack of informed consent, perhaps negligent hiring and supervision. Certificate of merit you need to file when you file a medical malpractice complaint to show that you've met with a physician or specialist who says that there is merit to the case. So also in a construction accident case, you're going to want to have allegations of, the violations of statutes for the different parties involved. So you're really going to want to have detailed causes of action, if not detailed specifics, if that makes sense. Every possible cause of action you want to throw in there. So like in a construction accident case that I gave you a sample from, we named the general contractor, the sub, we named the rental company. We pled negligence. We pled all the labor law statutes. We pled product defect in case a lift tipped over, in case that's what was the cause of it. So you want to just make sure you have it all in there. Now, one of the differences in a federal court complaint is you really need to specifically plead jurisdiction. You need to cite the statute, the diversity statute. You need to specifically identify where the party resides. There's important language in there. And you need to put the amount of controversy in a federal complaint. In New York State, you do not need to put money in the ad damnum. You could just say that the amount in controversy exceeds the jurisdictional requirements of all states. You'll see it in of all the courts in the state. You'll see some samples of that. Federal court, you need to put an ad damnum. You need to have an amount. You need to put it in the complaint and in the civil cover sheet, which we gave you an example of. So just be careful. Look at the examples on doing that. So in the complaint, you want to make sure you follow the proper format for state or federal. You want to make sure you have everybody named in there. You make sure you have all the causes of action in there. Then you want to have it verified by your client. All right. Plaintiff's lawyers can verify complaints if you attest that you're verifying it because the plaintiff lives outside of the county where your office is. But I don't like to do that, only in an emergency or last minute, just to get it done with the consent of the client. Will I verify it? Otherwise, have the plaintiffs verify all complaints. You'd be amazed at people that could be unhappy and come back and said, I didn't even know they filed a lawsuit and they haven't done anything for me. And then you show them where they verified the summons and complaint. You say, well, you did sign off on it and I did file it and you did verify everything. Also, moving for default judgments, it's a lot easier if there's no answer, if the complaint is verified, because then the facts are deemed prima facie facts of what happened because the plaintiff verified it. If the lawyer verifies it, you cannot move for a default just on your summons and complaint verified by you. You would need a separate affirmation attesting to everything from the plaintiff. Just a little practice tip there. Once you get the complaint done, signed by everybody, you have all the covers, you're ready to rock and roll with it, then you need to make sure you serve it timely and properly. Process of service. Don't mess around. The Academy, we've got great sponsors who can do it. Use a company that's known for process serving. They know how, when, where, why, different types of cases. Spend the money, have them serve it. You'll get an affidavit of service that once it's served, you then have to file that e-filing, whether it's federal or state court, that it's been properly served, and then you're good to go once that's done. The other thing is in federal court, they have a nice thing where you can actually invoke a waiver of service where you can send the complaint via like FedEx to the defendant with the proper forms you can find online. And you can say, if you agree to waive process of service requirement, sign this form, send it back. It gives them extra time to put in an answer and it saves you from having to hire a process server. If you're worried about it, just get a process server and don't mess around and file it. All right. So process is important. It all has to get served in time from the minute you file the complaint. Generally in New York State, you have 120 days to serve process. If you don't serve after you filed it, then it becomes a nullity. And then if you don't take action for a year, I've seen issues where the defense actually moves or the plaintiff moves for default judgment late after a year, having gotten no response. And I've seen the court under CPLR statute dismiss the case. If you file a lawsuit and take no action for a year, your case must be dismissed. It's not even discretionary by the court. So keep that in mind as well. All right. Then once you've filed, then you're basically waiting to hear back from the lawyer and or carrier, but the lawyer for the defense. That's where all of you, my defense friends, will jump in now. You'll get word maybe earlier or maybe not, and the complaint shows up, and then it's time to get going and put in your answer. We're going to talk about all of this. So sorry to my defense and carrier friends today that a lot of this was really what the plaintiffs go through to get it into litigation. But what we'll talk about in part 3 next month, only a few weeks away, March 4th, I believe. We're going to talk about now getting into discovery. And basically, once issue is joined, that is an answer comes in or all the answers from the multiple defendants come in. That's when issue is joined. Then you file for a preliminary conference in state court, in federal court. You'll follow the rules, which will usually involve filing a case management order and appearing before the court and working some things out in advance. We're going to get into all that next month. And that's the first part where you're really going to roll up your sleeves and get strategic on the items that you're going to demand and disclose in discovery, on the depositions you're going to take, and who and what you're going to want to establish. That's where you really get into the meat of building the case to win it before you walk in for trial. So that's what we're going to talk about next month. We've got a minute left, and then we're going to get to all the questions. And just in closing, keep in mind, jurisdiction first, then venue. Decide state, federal, then decide who to name. Make sure you name everybody with placeholders, throw in all your causes of action, get it served properly, and you're good to go. All right. So Rick, how are you? Is asking, does jurisdiction require that a cause of action also relates to the sued party as well? For example, a party sued on a contract and isn't a party to the contract, or sued for a tort and defaults, but isn't alleged in the complaint to be one of those tortfeasors. So if I'm understanding you correctly, the only way to answer this is if you're suing somebody, then you have to have standing and jurisdiction. I presume standing. So to get somebody into court, you have to allege that they've committed a tort or a breach of contract or whatever the case is. You can't get jurisdiction over anybody unless you're suing them and they're named party. So everything I'm talking about is for defendants. If it's a non-party or somebody who's not going to be subject to the litigation, then the jurisdiction issue doesn't even apply. So it only relates to the sued parties. Okay, I hope that makes sense to everybody. All right, Vincent is asking, could I provide the case law that supports the position that a judgment is a nullity where the venue did not have jurisdiction? I don't have a case off the top of my head, but I guarantee you someone on this group can throw it in there. If not, just do a quick search. It's going to be black letter law. If there is improper jurisdiction, either personal jurisdiction or subject matter, then the case can be dismissed all the way after verdict and appeal. So you want to make sure you have that taken care of. And the case law should be easy to find. Victoria's saying, isn't that based on the long arm statute? I'm not sure. That's the only thing you said isn't that based? So I'm not sure what you're asking. But yeah, the long arm statute, it's the long arm that reaches to parties who are out of state and pulls them into jurisdiction, hence the long arm. But you still need those contacts. If you're going to reach out with that long arm and pull them in, you have to have an explanation for how you're able to pull them in. Either they have contacts here, business contacts, principal place of business, the occurrence happened here. There has to be some basis to reach out with that long arm and answer that. And that's CPLR 302. Actually, no, that is the first one we talked about is the long arm jurisdiction. And that is, CPLR 302. All right. All right. All right, next question. Matt, my good friend, Matt Kaufman. Also, LLCs are not treated as corporations, but you have to establish that every member has diversity with the plaintiff. Yep, so look into that with the LLCs. Thank you for that comment. All right, Stephen, sometimes with ski cases, the back of the ticket dictates that you agree to bring suit in the county where the ski mountain is. Be careful. Thanks, Steve. Usually those are not binding. Those, at least in New York State, anything on the back of admission tickets, ski tickets, amusement park tickets, those are void under the general obligations law per public policy. I believe it's section 5-326. Someone can check me on that. But yeah, all that boilerplate language is void, including choice of venue. So at least in New York, you don't have to worry. And in most places, that stuff doesn't control whatever's on the ticket. All right, Lei Song is saying, besides travel distance to the courthouse, what other considerations are there for choosing a preferred venue? Again, it's the jury pool, whether you think the jury pool is right for your type of case, whether they're going to be liberal and you want that, whether they're going to be more conservative and you want that. So those are the types of things that you want to think about primarily. You're going to want to think about moving your case where you feel comfortable and whether you like trying this case if it has to go to trial in that venue. If not, then pick someplace else. Elena, how you doing? Okay, if defendant doesn't raise the affirmative defense of jurisdiction, isn't it waived? And if they do raise the affirmative defense, do you recommend asking them to stipulate? Great question. So jurisdiction is never waived. You can always argue it. I believe on personal jurisdiction, claiming that process of service wasn't proper, they do need to allege that. And that sort of personal jurisdiction, process service usually interacts subject matter jurisdiction and the state having jurisdiction over the subject matter and the party. You cannot waive that. So if there's an issue of service, what we do is we always ask when we see an affirmative defense of improper service, meaning no personal jurisdiction because they have to be served properly. Usually we just give them the affidavit of service and ask them to stip it out, and they will. And if you're on the defense side and someone gives you a affidavit of service, it would be in bad faith to leave that affirmative defense jurisdiction in there. The other thing is we do it as a matter of course in our firm that if a defense firm ever asks for an extension of time and they're not going to be able to timely file the answer, we will give that to them. But in that stipulation, as a quid pro quo, we say we'll give you another 20 days, 30 days, whatever, but you're going to agree to waive the affirmative defense of personal jurisdiction, meaning they weren't served properly. Okay, so I hope that makes sense. All right, Maria DeGennaro. Do I have any experience in Suffolk Supreme Med Mal, and how plaintiff friendly is Suffolk? I haven't had a Med Mal case out in Suffolk in a while, but we've had some plaintiff cases go out there that have gone our way. So, I would speak to someone that's more a Long Island practitioner. I'm more in New York City, although we have cases in Nassau and Suffolk. There's not a ton of them. I'll certainly take Suffolk over Nassau every day of the week for every type of case. But Suffolk, from what I hear, the word on the street is it's not that bad a place these days for plaintiffs. I just don't know in Med Mal. In Med Mal, in my opinion, you have to prove your case beyond a reasonable doubt, no matter where you are. And there's some really bad venues, but that's for another CLE. Don't get me started on that. Matt, on choosing venue, Matt Kaufman again. In Manhattan, what chance will there be that a member of the jury or close relative is a physician? A really good chance, right? New York County, we get physicians, lawyers, professionals all the time on the jury. I like New York County because the way that I try a case, I try and be very logical. If you were in a jury box on trial, it would be just like what you're doing now, listening to me. So I try and explain the issues in the case, make it very clear. And I find that New York counties, Queens County, Kings County, they get it. They get me. They get explanations. And sometimes you want that, but sometimes you don't want somebody too smarter who gets you, depending. They could be more conservative. They could be more tort reform. So Manhattan can be a little tricky, but I wouldn't be afraid to do a Med Mal case in Manhattan. I'd much prefer that over places outside of the city because they're not as scared to comment on the care rendered by doctors when you get out of the city. Most people don't want to feel like they're in a position to question a doctor. They just don't. It makes it really hard. All right, Matthew's also saying in federal court, many judges require every attorney appearing before the judge to file separate notice of appearance. I've witnessed judges marking cases in default on appearance when the appearing attorney has not filed. Yeah, thanks, Matthew. So that's, federal court, like I said, you got to be buttoned up. You cannot show up as a per diem lawyer who's not affiliated with the case, whose name isn't on the docket. You will get reamed by the judge. So any lawyer in your firm who is appearing either on phone conference, Zoom, or in person, you cannot open up your mouth on a case that you're in court for or in a conference for unless you filed a notice of appearance. So you could file that morning or the day before, but you better get it done. We always do that in my firm. If it's a lawyer covering a case for us who hasn't filed a notice of appearance on it because they're not involved, but we need them to cover an appearance or conference, we'll immediately get that notice of appearance filed. So make sure to do that. Thank you, Matthew. Elena, again, if you're deciding whether to add a spouse for loss of consortium, does it affect the amount of damages being demanded? Usually not. I'd like to say as a rule of thumb, think of the spouse, the value of the spouse's case is 10% of the value of the case. You settle a case for $300,000 and it's a husband and wife as plaintiffs, hopefully they're going to use the money. It'll go to both of them. If it goes to trial, that same case, the jury may award the injured plaintiff $250 and maybe $25,000 for the loss of consortium. You do marry for better or worse, rich or poor, broken leg or non-broken leg, right? So it doesn't affect the amount of damages being asked. Again, spousal loss of consortium claims, usually it's the only time you see a separate line item is when the jury's writing it on there. Otherwise, settlement is just going to be one number, okay? And the spouses have to share it or whack it up however they see fit. Kent is saying, in the state of Washington, loss of consortium extends to the children. Would you include their names in the complaint? So, it's interesting. So it depends on the proceeding, right? So in a death case, the children, if there's minor children as distributees, they are entitled to be compensated. Same way in a death case, if it goes through the laws of intestacy and there are a lot of kids or siblings. So all those names don't need to be on the complaint. Just because you're the beneficiary of the funds when the claim is done, you don't have to be in them. But if you're making a specific claim for a specific loss to the children that they can really define separately from just being the kid that, the parents got injured or can't take them to hockey practice or all that, they usually don't have that right. But in Washington State, it can't hurt if the children are in there. Again, you'd have to put their initials but you may or may not need to put them in there. When in doubt, I'd put them in first. You can always remove them. All right, Kemp. Thanks for tuning in from Washington. All right, Matthew, again, hey, man, I got to get you to do these CLEs with me. You got so much information. Matthew Kaufman saying some jurisdictions are more liberal than other for John Does, as long as the John Doe is clearly described. So what Matthew's referring is you can't just throw John Doe in there and say, I'm putting this as a placeholder. You would put in there upon information and belief, there was an individual who was part of this. We're attempting to find their name. For now, we'll refer to them as John Doe in the complaint, and we anticipate substituting that when the identity becomes clear. All right, Ashley, my question sent before I was done typing. How would you confirm that the parties on a police report were actually the ones involved in the accident? I had a case where we sued the parties on the police report, and the defense was that it was the brother, not the person named on the report, and the police report was wrong. So again, that can happen. I think you're safe if you name everybody on the police report. If you get a letter, again, be on the lookout for those letters of acknowledgement from the insurance companies and or defense counsel of who they represent, and confirm everything with them. They should be the ones saying, no, even though they put that person's name, that person wasn't the driver. And then you may have to do depositions. I wouldn't take anybody's word for it. I'd go with the police report. And as long as you have the owner of the vehicle, that's the must. The owner, the registered owner, and you do your own due diligence. The owner, you should have a plate number, have that plate run, have the address run. So you need to do your own due diligence to confirm that you have the proper parties. It'll be rare that they're on a police report and they're not, and you can usually sort that out. Even if the statute is expiring soon, just make sure you get the owner. That's the key one, and you should be able to figure that one out pretty quickly. All right, Adam, if there are municipal parties with potential qualified immunity, would you be exhaustive and name potential municipal employees too? So if you know the name of a municipal employee that was really involved, then I would put their name in. Why not? But in general, I'm not one of those. You won't see complaints coming out of my law firm that have like 30 defendants on there. That's not our style. I know you're supposed to throw the kitchen sink in, but I believe the kitchen sink is on the causes of action, not on naming every single person. The reality is, and this is where it can help out to speak with the adjuster, the claims representative, or if the lawyer gets involved, both defense side before you file it, you can usually sort it out and get affirmations to limit it. Who's not involved, who is involved. If you're suing the municipality, let's say an example is, it's a city hospital like Bellevue in New York, right? You don't need to name all of the nurses and radiology techs and doctors and staff doctors. You've got the hospital in, so any of their employees are going to be fair game. You don't need to name them. I only like to name individuals if I really believe that individual was an active tortfeasor in the case, not as a fishing expedition to do that, okay? All right, Leigh, how to properly draft a course of conduct type of complaint. What level of specificity? So I'm not sure what you're referring to as a course of conduct. Again, the cases that we see litigated, it's going to be a contract, it's going to be a tort, it's going to be for an injunction, whatever it is. You need to give enough specificity to put your adversary on notice of what the claims are so they can investigate them. But you don't have to get into really, really nitty-gritty details. That's what supplemental discovery is for. Details are asked for in a demand for bill of particulars or interrogatories, okay, for that type of thing. All right, Louis Luciani, is there a way to overcome the 90-day notice when the client comes to you past the 90 days? So I believe you're talking about for a notice of claim. So what will happen is if, let's say, someone comes to me and it's a medical malpractice case, and they come to me after the 90 days have expired and it's a municipal hospital. So the first thing you need to do is explain to them that they came to you late, that there is a 90-day notice of claim requirement, and that they could be barred from bringing the case. That you will file for a motion for a late notice of claim based on the fact that in medical context, it helps because usually they have the records and that's deemed to put them on notice. You'll research the law and see, but the key is the only way you get past the 90 days, ignorance of the law is not a defense ever to not filing timely or to statutes of limitations. So the only alternative is to file a motion for leave to file a late notice of claim, which you would then attach as an exhibit, and then you You file it along with the complaint, depending on how far underway you are. But yeah, it could be a problem. So as long as you say something and then try, as opposed to a client coming to you and you filing it only for it to get rejected as being late, then you look bad. You need to let them know up front, if we do take this case, you need to know you've already lost under the statute. We will try and we'll do a motion for a late notice of claim, but there's no guarantees at all. All right. Russell is saying, by naming many potential defendants in a cause of action, do you run the risk of being hit with costs and attorney's fees if a defendant was at best tangentially involved and are ultimately dismissed? I haven't run into that situation, but I think if your adversary can make a good argument that you've named 50 people in the defense, they've told you no one's involved, they've given you affirmations, and you keep them in the case without stepping to let them out or discontinuing against them, then you could get in trouble with the judge. If you're truly keeping somebody in a litigation that has no involvement and they've proven it to you. Now, if someone asks to be let out from the defense side, if they're like, oh yeah, Nurse Smith had no involvement in this, like, okay, I don't need Nurse Smith in it. If you can give me something, send me an affidavit from Nurse Smith saying she was out of the country that week, I'm not going to keep them in. But you need to, always do it nicely with your adversary and say, hey, I got to protect myself. I got to cover my ass. I don't want to be sued for malpractice and not having all the proper parties in. So you have to give me something. You have to work with me and let him out at that time. But again, it goes back to, don't name everybody. It's a waste of your time. It's going to create more issues. Name the key entities and the key players you know about. Okay, that's the key. As long as you do that, you're going to be all right. Don't feel like you got to name everybody. It's just going to, frankly, annoy people. It's going to annoy the judge. It's going to get you off on the wrong foot with your adversary. And like, look at this. This person named 50 people. Come on. So be cautious with it is the best way. All right. Thank you, Russell, for that. All right, Matthew is back. Not only does the CPLR provide for waiver and acknowledgement of service by mail, but there's appellate division case law permitting obtaining an immediate judgment on service of process costs if the defendant rejects the waiver. You must list on the top of the pleadings that a waiver was previously requested on a specific date. See, now that's a great thing. So what I was talking about, you can do in federal court, you could do it in state court too, meaning state Supreme Court. I've never done that because I'm always worried and delays. It's easier just to get the process server out there. But yeah, there are ways to avoid process serving. And if you follow the rules, you could do it right, whether it's state court or federal court. So thank you for that, Matthew. All right, Gretchen, what about specifying the location in the complaint? I see some cases have a different location in the complaint or notice of claim than in testimony, which seems to undermine their case in my mind.
Attendance code number 2 is WIN 218. That's WIN 218.
Yeah, that's weird, right? You want to make sure. That's the other reason why you're going to want your clients to verify answers and to verify complaints. Because we're lawyers, we weren't there. We don't know anything. We're working off the information we're provided. And just because someone tells us it happened somewhere doesn't mean it did. So have the clients verify things, do your own due diligence. The location in the complaint should be the same location that they testified to. If they don't, you're the plaintiff and you say that they tripped and fell at a building in New York County and you bring the case in New York County. And then it turns out, oh, I meant Forest Avenue in Queens, not New York. It should have been in Queens County. Well, you might be running into some venue problems, some jurisdiction problems. So you need to know that really early on. If you're on the plaintiff side, make sure everything aligns. If you're on the defense side and they say that it happened at the wrong place during a plaintiff's deposition, then have that conversation with the plaintiff. Decide if you think you want to move venues, if it's appropriate under these circumstances. If, for example, the venue was decided based on the location of the accident, if there's no other ties, then you're in improper venue. So you got to be super careful about that. If you're within the statute, you could usually stip to amend, stip to transfer cases. You can usually work it out prior to motion practice, which I suggest you try and do. But that kind of, you don't want to find out that you're in the wrong place. Okay. Malik, borrowing statute when accident occurred out of New York and plaintiff is citizen of New York. I don't know about the borrowing statute, if that's what you're referring to. But if an accident occurred outside of New York and the plaintiff is in New York, then you may have to go to that other jurisdiction unless you can find some way to get jurisdiction over the main defendants in your case. Otherwise, you can't bring it in New York if the tortfeasors are all out of New York. All right. Todd Cook, thoughts about non-working spouses, children up to collegiate age that are non-working, and the elderly in regard to the Grievance Families Act and the ability to sue. So yeah, for any of you following the Grievance Family Act, man, the Academy, we have been pushing with other entities, and Judge Hochul just does not want to sign this thing. And so the Grievance Family Act is a whole nother story.
Governor, Governor Hochul,
Governor Hochul, what did I call her?
Judge.
Judge, oh, governor, yeah, whatever. Uh, I'm sure people have other names for her than I've just given. But look, if they're non-working spouses, they're children, they're not named in the suit. Okay, these are all individuals who have suffered. But generally speaking, if I break my leg and that means I can't take my daughter to practice every day, she doesn't have a cause of action in New York for that. All right, if I get hit by a bus and she wasn't dependent on me, then there's no cause of action on that. So it's going to depend on the facts of each case. But as of now, non-working spouses, children, they're only going to get what they're entitled to if it's a death case under the law. Otherwise, if it's just an injury case, unless you can show, I don't know what you can show, but usually they're definitely not named as parties to the case. Francine, if the sole plaintiff in a New York case moves to another state during the pendency of the case, can the defendant then move to dismiss the case due to lack of jurisdiction? I think they can make the motion. I don't think it'll be successful. People can move. The key is where they were located when the complaint was filed, at the time of filing. So if it's a New York case, everyone's in New York, plaintiff files it in New York, and the case has been litigated, and then they move to Jersey a year later, their case doesn't get thrown out of New York because they moved to New Jersey. All right. So it's at the time that it's filed. You have to have jurisdiction. All right. In federal court in Washington, and corporate defendants' discovery responses were like 15 pages. What's the best strategy to press them? Any books, resources you'd recommend? Thank you. So I'm not sure, SA, what the question is. So the 15 pages of discovery responses, depending on the case, that can be a lot of info. It could be no info. I can't recommend books or resources other than you're entitled to get the discovery you've demanded. And if they're not giving you what you asked for that you're entitled to under the law, then you have to have a meet and confer where you say, listen, I'm entitled to it. And they're saying you're not. And then you read the federal judge's rules. You tell them we've met and conferred. They've objected to all of your discovery demands. You believe you're entitled. We need the court's assistance herein. And you spell it out. You send them a letter. And then the court will usually set up a conference and tell them you have 3 weeks, give them the discovery, or they'll adjust it however they see fit. All right, 7 minutes left. We're cooking here. Richard is saying, is the mention of plaintiff to be responsible for subrogation claims that appears in a release automatically void due to General Obligations Law 5-335? Richard, man, you're asking the wrong question in the wrong CLE. I don't have an answer for you on that one. I would just do a little research. Sorry, I don't know that GOL, and that's really sort of out of this wheelhouse. Happy to offline with you if you want to Zoom with me and see if we can help you get to the answer that you need. Hey, Audrey, how are you? In a professional malpractice case, psychotherapy, can venue in New York County be based on defendant's office address listed on the internet, at least 2 different websites, even though plaintiff never saw defendant in that office? That's a great question. I would argue yes. And it's going to depend on the extent of it. But if they maintain offices and they say they're doing business, so let's say, the psychotherapist is based in California, but that psychotherapist sees patients in New York, has an office in New York, is licensed to practice medicine in New York, then I don't think you've got any issue bringing it in one of the counties where either if your client lives in New York or where the defendant's practicing. But yeah, and that's this whole new telemedicine and tele everything, right? I believe that you can get jurisdiction if they're practicing where the patient is. I think that's what controls it. So if I'm sitting at my desk in New York and I'm getting treated by a therapist in California and I want to sue them, the question is, can I get jurisdiction in them in New York? So I would do some quick research saying, does telemedicine with a practitioner out of your state, but you're located in a different state and receiving that, how does that affect jurisdiction? And do they need to be licensed? I don't know the answer off the top of my head. I'm sure one of you does, but I believe if I'm a doctor in California and I want to do telemedicine for a New York person who lives in New York, I don't think you can do that on telemedicine unless you have privileges in New York State to do that. I could be wrong. Check me on it. Somebody here will probably know. But yeah, when you start getting into this world of the internet, this gets back to my Hyatt Acapulco example. Sometimes you got to test the waters, do your research on contacts on the internet, on marketing, you know. And if you find they got a lot of stuff all pointing into New York, I think a court could find, you list all those, they could find that that's good basis to get jurisdiction over them. Nice to hear from you, Audrey. All right, Felicia, do you see a loss of consortium claim being successfully made for a domestic partner? Look, loss of consortium claims are throw-ins, in my opinion. No one's ever going to get a lot of money in a loss of consortium claim. And whether it's a domestic partner, and again, a domestic partner, I don't know if under the law, I know spouses can get consortium. I don't know if technically a domestic partner can get loss of consortium. But again, I wouldn't push the issue that hard. I would focus on the injured party because I can see that if you're trying to bring in a domestic partner, if you name them, if the law isn't clear one way or another, that could just take away from the meat of your case that you're working on. So I would do a quick little bit of research. I don't know the answer off the top of my head. I'm leaning against domestic partner getting loss of consortium. And again, it's probably not worth that battle, but check me. I may not have the right answer there. All right, Charles, if the plaintiff injured in a medical malpractice case is very old with no expectation of future income, is it worth litigating? So look, we have that discussion a lot when people contact us about taking on cases. And oftentimes it's an elderly person that's in the hospital for one reason, and something bad goes on, and they're now in the hospital for another few months for another reason. Their life expectancy is short. They would have had pain and suffering otherwise. There's usually a really big Medicare lien. So you have to, see how bad is the case, what's the potential on getting it resolved, how bad is the injury compared to why they were probably in there in the first place. Knowing med mal cases are tough. Most people will pass on those for that reason. Frankly, it's the rare situation that we'll take on a case of an elderly person who's not working, who's not supporting anybody for their pain and suffering, because there's going to be big liens. It may be hard to distinguish the pain and suffering from the malpractice, from the pain and suffering they would have had anyway, since they're in the hospital. So it's got to be fact specific. If I had to hedge and just answer that general question, yes or no, generally it trends towards the no for those reasons. All right, Gretchen, it's usually enough to file representation under NYSEF in state court. I never had a judge tell me to file a separate notice of appearance. So we're talking about, Gretchen, federal court. If you're in federal court and you are appearing for any matter for a party, you have to have a notice of appearance filed with PACER, with the federal court. State court, you're not worried about that. Anybody can show up. Okay. All right, Vincent. If a judgment is obtained in a foreign country without a basis for jurisdiction over the defendant, what case law supports the nullity of the judgment, even if the defendant initially appeared pro se and did not oppose lack of jurisdiction? All right, someone out there needs to hit some Lexis. It should be a very easy search. You say, can jurisdiction be waived in New York State? I would ask that. Can jurisdiction over a foreign entity be waived? You're going to want to look up that sort of those fact specifics. And just because you get a judgment, you can file suit against anybody and get a judgment here in New York against an entity in Abu Dhabi because you filed it and you said you served it properly, you did everything right, you get a default. That may carry no weight at all. They can come in and say, this default means nothing to us. You have no jurisdiction over us. This isn't worth anything. You still have to have jurisdiction. You can't bypass the system if someone out of the jurisdiction isn't aware. So you gotta be careful there. The bottom line is, remember, you have to have jurisdiction. You have to. You can't sneak around it. You can't get consent to it. You have to have it under the law. Adam, thank you. The cases we're thinking concern alleged wrongdoing directly by a building inspector in a small town and their private business affiliates. Lots of overlapping, but we anticipate qualified immunity being argued. All right, so it's a building inspector You want to name if you think that building inspector did something wrong. Um, if there is some type of state entity that they're working under the Department of Buildings and there is immunity, that immunity is going to trickle down to employees. If the government entity or whatever entity has immunity under the law, usually the employees do as well. So try and name some entities that would not have immunity and see if you have some luck there. That's the best way that I can answer that. Kaylin, I have two offices in Brooklyn and Suffolk, Long Island. Can I verify the complaint for a client who is in Suffolk complaint? List the Brooklyn office. I wouldn't do that, Kaylin. And I see we're at 2:30. You have an office. You have to say that I do not maintain an office in the county where the plaintiff resides. So I wouldn't do that. That's playing with a little bit of fire there. All right, there's a few more. Sorry, I couldn't get through them, folks. If you want to shoot me an email directly, I'll answer it within 24 hours. I'll answer your email. So just send me your question there if I didn't get to it.